Hi everyone, Shawn Waldman with Secure Cyber Defense, and I want to welcome you to episode 2 of our video podcast series. I'm joined today by Andy Vollmar with Bruns, Connell, Vollmar, and Armstrong here in Dayton, a local law firm. Andy and I have worked a lot together over time, doing presentations about cybersecurity and legal. Andy, you're a great resource. I know we've had a lot of success talking in public. It's actually been a long time since we've seen each other, so we were spending some time just kind of getting caught up, before we started recording. But I wanted to give you the opportunity to just kind of explain, introduce yourself and your firm, and just kind of go from there.
Yeah. So our firm is in Dayton and Cincinnati.
Okay.
And we represent businesses, mostly, some individuals, but mostly businesses, and we really have a focus on small business representation.
Okay.
And helping those clients through a variety of things. A lot of it is litigation, but some of it is business planning as well,
okay.
Business formation, and advising clients through a variety of areas from licensing to employment matters.
Okay, great. Something that I know when I first started Secure Cyber Defense now 5.5 years ago, I certainly would have liked to have been advised at the very beginning, right, when starting a company. So that's great that you guys offer that type of service. So let's just go ahead and jump right into cybersecurity. There's a lot going on. I know you and I had talked just before we started that we, as Secure Cyber Defense, we started doing breach response and started having some interaction with law firms being retained on breaches and those types of things. So now it's kind of interesting to kind of get your perspective. And I also want to eventually, during this podcast, touch a little bit on cyber insurance, because that's something that that we've talked about quite a bit. So I guess the first thing, Ohio introduced a safe harbor bill, Senate Bill 220, and it started to get talked about a lot from the state, and then it got quiet a lot over the last couple years. So basically, can you kind of explain Senate Bill? It was Senate Bill 220, if you want to look it up in Ohio. A number of states have started falling in line with offering safe harbor clauses. The general gist of it is, be in compliance with a certain number of standards, and then what? So how does that protect an organization, and how would they enact that if something would happen?
Yeah, basically what it does is it sets up a legal defense in any litigation. If there was to be a data breach, what the statute does is it protects the business if they've met those minimum standards and they can show that they have a written policy for securing their data. And so if that business were to be sued, then they could say, look, here's our compliance information. We've done we've met all the standards that are outlined in the statute, whether that be, for example, the statute references HIPAA. So if you were a healthcare provider and you could show that your systems or your policies are HIPAA compliant, then that would be an affirmative defense if you were to have a data breach and then you were to, for example, have your patient's data published on the internet.
The statute references, is it called a tort?
Yes.
What is that?
So a tort is really a common law lawsuit. So basically it draws upon legal precedent. And in the case of data security, that would probably most likely be a breach of privacy or exposure of private information about an individual. So that could be anything from credit card information to private healthcare information that is disseminated, put into the public domain, or captured by someone unauthorized to have that information. And that would be a breach of a person's common law right to have their personal information private.
Okay. So it was interesting you mentioned, it's one thing to be in compliance with one of the 10 regulations. Let's say it was HIPAA, just because you mentioned it. You said something very important that I caught, and you said it's important to make sure that it's in writing. So that means that an organization needs to have written policies and procedures. In other words, if you were representing an organization and something happened to them, they couldn't just walk up to you and go, yeah, we've been doing all these things, just take our word for it. So there's got to be some documentation, some history, some policies, contracts with providers that are helping you stay in compliance. My guess is there's got to be a lot of proof.
Yeah, there's got to be some meat on the bones of the skeleton, so to speak.
Okay.
So you're absolutely right. There should be a written policy in place. There should also be evidence of periodic audits. And that's a really important concept, because you want to show that from time to time you have looked back at your policies, you look back at your practices to see whether your practices are in compliance with the written policy.
Yeah.
And then the other thing that people often overlook is that it's very important, if you have business partners, if you have other companies that you would share information with, so let's take a healthcare facility again. So let's just assume it's like a hospital, but they contract with a radiologist group to provide services. Well, that hospital should also make sure that their business partners also have data security policies and practices in place.
Yeah.
And that's part of the due diligence that is required in order to meet the standards in the statute. So if you want to use that as a defense, you really have to have some infrastructure built up in the way of documentation.
There's been a lot of cases, since you bring that up, there's been a lot of cases where an organization has been breached through a vendor. If it's the case of Target, for example, Target was breached through their HVAC contractor. And we do a lot with Department of Defense companies, and the supply chain is very important, right? So you've got a prime contractor, and they have some responsibility to make sure that their subs are also compliant with the regulations. So I think that's probably a good point, and probably something that would be overlooked, to make sure that everybody downstream of you is in compliance.
Well, and not only that, you want to make sure that the people you're doing business with have cyber insurance as well.
Right.
In a typical business transaction, a typical business contract, you would see that the contract includes indemnification provisions where the contracting parties would have to represent that they have liability insurance, and then also that they're agreeing to indemnify each other from one another's actions.
Okay.
So that if there was some kind of lawsuit from, let's say, Target's HVAC person was really sloppy with their data practices, that HVAC company would then have to indemnify Target from their actions. So that's very common in I'm talking across the board in business contracts. So that has now moved over to the cyber area, and now you see where that's a pretty common practice.
Okay.
Where, you've got to certify that you've got insurance if you're going to do business with company X, Y, and Z. Okay.
Well, so before we move on, I want to jump into insurance, but I also want to key on one other thing that you said a minute ago, which is also showing in your documentation that you have periodic audits.
Yeah.
We get asked that a lot. We do a lot of those audits for companies, as you know. I often get asked how often they should do that. But I'm thinking, there's nothing hard, solid in the law that says you have to have a third-party audit every year. But I think what we recommend to most organizations is that they not only have the periodic audit, and they can define what periodic is. If their budget dictates that it's every year or every 2 years, so be it. But we've also had a lot of companies rotating audits. So they'll not stick with just the same company. we've been called quite a bit on a company that's had a really good relationship with a cybersecurity company, but they want to change up. So they want a different set of eyes. And then on a future podcast, we're going to get into the difference between pen testing and vulnerability scans too. So we get that a lot. Well, how often should I be pen tested? So it was good that you brought that up.
Yeah. I think it's an important concept, and you want to be able to say, at the end of the day, if you're sitting there in a deposition room, that could be very well be your Exhibit A is, look, we've tried along the way, we've made reasonable efforts, we've done our due diligence. That's what you're going to need to be able to say in order to invoke the protections of the law.
It's funny that I must have gotten that term from you, because I say those words, reasonable effort, a lot. And that's really what it comes down to, because, we get asked, well, how much should I spend on cybersecurity? Who are you? What do you do? What regulatory bodies do you have to comply with? Right? Who are your vendors? So there's all those questions that come up. It's the same thing with how much cyber insurance should I have? There's no table for that you can look at and go, well, I'm this size, I have this many employees. Oh, I should have this much. So, that's what I always tell people. At the end of the day, you do have to sit and tell somebody that you took a reasonable effort. So you can't sit and do nothing, but it's also not reasonable for you to spend some enormous amount of money on everything cybersecurity wise, when it's finding that sweet spot, I guess, is one of the most difficult things.
And I think a big component of that is just knowing what you have. So there have been cases where literally people forgot what they had. They forgot that they were storing years and years and years of data, which, again, getting back to the policy, that has to include some form of data retention. Now that's going to drill down, and it can be very industry specific. So healthcare providers may be required to keep certain data for a certain period of time by statute, whereas if you're selling barbecue sandwiches or something, you might not need to keep the data as long, So it really is industry specific as to what you're storing, how long are you storing it, and then you have to have the discipline to go back and say, hey, if I'm not required to store this stuff, I really shouldn't be storing it and archiving it, because the less you have to actually protect, the better off you are.
I know when I was in, I did 19 years in local government in this area, and the data, we were required, local governments are required to have a data retention, public records type retention document that says, how long you're going to keep things, and the Ohio Records, Committee approves that. And it surprises me how many organizations want to hold on to everything forever. And I think there are some ways that you're opening yourself up to some liability, where if something, let's say you were only required to hold a document for a year, and you hold on to it for 5. And if something happens, even if your records retention says that you only have that email or that document for a year, and something happens legally and discovery is made, by you having that record, even though it's outside of your retention period, that is still discoverable, correct?
It absolutely is. And this has become, it's a little bit of a segue away from data security, but I think it's so important for businesses to know that if you do find yourself in litigation, typically the first thing that they ask for is all documents, meaning all emails, all text messages, everything. And that can be an enormous task to gather all of that information and then turn it over. And often it's the case that they're asking for it in native format, so they don't want you to take your emails and create PDFs and produce those. They want to see the native format to see if there's been any sort of manipulation or doctoring of the data, and that just can be a huge expense. Now, I'm not saying that people should delete information. What I'm saying is have a reasonable policy surrounding what you're keeping and what you're deleting or discarding.
Sure.
And then have the discipline to stick with that policy. Otherwise, you can find yourself in a real mess.
Right. Absolutely. Well, so let's go into cyber insurance for a little bit, because we kind of ended on that topic a little. Anything new in the cyber insurance industry? So our last episode, we had a cyber insurance person here, and we talked about what the policies do and how they work. We still are asked a lot, should I have cyber insurance? Yes, you probably should. What are any pitfalls? I mean, what is the attorney aspect, your aspect of cyber insurance? What's going wrong?
Yeah, so I think the starting point is that in a typical general commercial liability policy, or what is sometimes called a CGL policy, it provides insurance coverage for damage to your physical structure building. In typical policy is going to say that we cover tangible physical property. Now, that does not include data. Data is not tangible physical property, but there can be no question that data is valuable. So it's from that, gap, if you will, in the CGL policy that cyber insurance was born.
Okay.
This concept of protecting the data that you store. Now, it's in my experience, we look at most insurance policies, they generally provide the same types of coverages, but that's not true necessarily with cyber insurance. So it's all intended to cover a data breach or a loss of data, but there's different types or ways of writing that coverage, and so you might see policies that read completely differently, and then of course there's different ways of practice or implementing the claims process, and so that can produce different results as well. So there's from company to company a lot more inconsistency than what you would typically see with a CGL.
Okay.
And I think probably one of the most important things for the people watching this to consider is, what is the amount of the coverage? Because that is where the insurance companies are more or less limiting their risks, is in the amount of coverage that they're writing. So it's not unusual to see policies written, for example, in the amount of $50,000. Well, getting back to what we've talked about, if you were to be, find yourself as a business in some litigation, and you have a discovery request, or you have, you're responding to a breach, $50,000 would not go a very long way.
No, it's not.
So if that's the limit of your
Right.
coverage, and I'm just throwing that out as an example. It could be $100,000. It could be, but it's important for, somebody might just say, well, I talked to my agent, I got coverage, got full coverage. Well, what's the amount of that coverage? I think that's an important thing to know. So, ultimately, I think it's a good idea to review your policy, have an understanding of what's covered and what's not, look at the exclusions, see if there's any sort of requirement that you provide certain safeguards as part of the underwriting as a condition of coverage, because the coverage might be set up based on your representations in your insurance application that you're going to do X, Y, and Z to protect data. And if you haven't done X, Y, and Z, then the coverage might be excluded. So you have to be mindful of all those types of things with cyber insurance coverage. And it's not just I can check that off my list and move on. Nothing's ever that simple.
But I think people think it's that simple.
Well, I do too. That's why I mentioned it. Yeah.
Right. I mean, I know, we both know that for a fact. I mean, just us operating in our separate industries, you and I both know that companies are going out and getting cyber coverage because they say they need to, or somebody tells them, well, so I'll contact my insurance agent, they'll get an underwriter, they'll ship me a form, I'll fill it out, I'll get $1 million worth of coverage, and I'm done. And in our experience, that's what's happening, and then they're not looking at the exclusion. So we have seen many breaches where they have I would keep in mind that once you add forensics and incident response and all the things that go, I'm not talking about legal fees yet, but all the things that go into aspect from us could reach anywhere between $250,000 and more at the end of the day, depending on the size of the company. Not every company is going to be $250,000, but that, yeah, $50,000 policy is not going to get you. It's not going to get you anything.
No.
So I always recommend that that folks, do get out and get cyber coverage. But I have always said, make sure that you have a legal representative review that said policy to look at the exclusions to make sure that it didn't, because we've had. Like, for example, we've had companies that have had incidences, and then it had involved like maybe some PII, some personal identifiable information had been released on customers. And then they go to get credit monitoring coverage, and they find out that that's not in the policy. So that's something that I think people, like, you have to think through that. So if you're handling PII, right, back to the barbecue guy, right? If you're just selling barbecue sandwiches, you're probably not handling PII, right? Unless you're taking credit cards, which is something different. But anyway, if you're a doctor's office and you have an incident, then you are probably going to need to provide some type of coverage for your clients. Retaining a law firm like yourself to review those policies.
Yeah, since we're talking about policies, and since we're sitting here in the middle of July in 2020, I think it's important to mention that there's a lot of businesses that have gone to work from home now, and that creates a different risk in many cases. And so it's a good time right now to update your data protection policy in your business to look at, is work from home covered? And then it's also a good idea to look at your insurance policy to see what kind of exclusions, if any, might apply to different scenarios. For example, remote working. These are all things that are new to us in 2020 because we've moved from working in a hopefully a secure environment in a workplace now to people going out to their own homes, and in some cases they're connecting to a server in a different location through their equipment at home, and it creates a whole different set of circumstances and risks, and it potentially creates different requirements legally to assess, what are we doing, how are we managing those types of connections and possible avenues for the bad guys to get in.
Well, I'm glad you brought that up. I would not have considered that, and we'll have to look at that. So thanks for the tip. On that topic, is it necessary for employers so if everybody goes home and works, is it necessary for them to list those addresses on the policy of the employees that work at home? Because we saw a case here in Dayton after the tornadoes. It was a business in North Dayton. Matter of fact, I was on a panel with that company. It was a couple months back, and their office was wiped out, and they had recently done some type of movement, and they had obtained that warehouse in the path of the tornado. They didn't list that on their policy. They had forgotten to call their insurance agency, and they ended up in a pickle because the insurance company was like, well, that location is not listed. Is that something, obviously we need to do that, right? Make sure that we're keeping our addresses up to date. Do they have to list the home addresses of all their employees?
Well, I think that's I would certainly look at your insurance policy in order to assess that. Now, certainly the CGL policy itself is not going to cover those home addresses, but CGL coverage isn't going to apply to cyber stuff anyway.
Okay.
But if I'm the insurance company, I might say, wait a minute, this is a different risk. The risk that I underwrote involved this business and these servers. Now you're bringing in a completely different set of equipment here. So, in fairness to the insurance company, it is a different risk. So I would look at that honestly, and I would also update my policy right now if you've got people working from home, because it really is different.
Okay.
It's different than people coming into a workstation that you control, that's in your environment.
Okay.
Because you don't know. You don't know who else is on their home, their home equipment. Who else is tying into their internet at home? You don't know that.
Okay.
You should know that.
We had actually, matter of fact, on the next episode after this one, we're going to bring in someone on this related topic of setting up a home office and how you should go about doing that. And it actually involves what some people may not realize is that you can have 2 internet connections at your house. So obviously we've run into that, right? As a cybersecurity company, we have assisted organizations with getting people securely working from home. But we found that a lot of times, with video calls and stuff like that, that obviously if you've got kids at your house and they're all watching Netflix and stuff like that, you're going to be competing for bandwidth. So one of our recommendations is actually, not in all cases, but to look at getting a second internet connection for that executive or for that work-at-home person so that they can have their own private network that can be compliant and that type of thing. So we'll go into that later. Let's talk about Ohio is a breach notification state, meaning that you need to disclose that. I think there's a lot of gray area on the word breach. That's obviously breach is a triggered word, and it's an official legal term which implies something. Talk about Ohio's breach notification process and how that works, and what's the definition of a breach?
Yeah, well, so ultimately, if you have reason to believe that your employees' data, your customers' data may have been compromised in some way, I think it's important for a business to seek out a professional at that point and find out just what exactly happened. I think you have to realize that you may not know in these circumstances. It's important to find out, okay, if someone else has accessed that data, what are the chances that they're doing it for, benign purposes? Probably 0. And so at that point, that's going to probably trigger your notification requirements, depending on what you find out, what you learn about what the event involved, what just happened in your system. I think it's really important, if there's any unauthorized access to your system, to assess as quickly as possible what happened, where did the data go, if it went anywhere, who accessed it, or is this an unauthorized access? And I think that if you get into a situation where there is an unauthorized access, then you have to assume that things are going to start rolling from there in a bad direction, and you're probably looking at having to notify your community, your customers, that the data has been breached, and that has to be done within a certain time frame under Ohio law. That's a statutory legal requirement, and so this whole process has to unfold pretty quickly. I think you have to err on the side of investigation, err on the side of bringing in some experts so that you have some idea of what you're talking about.
We combat ransomware a lot. We have a lot of companies that get hit by ransomware. Is ransomware considered a breach?
So if the ransomware comes onto your system and let's say it locks it down so that you no longer have access to it, but you can establish that it hasn't gone anywhere, it's just been encrypted on your server, you're probably not required under those circumstances to make a notification. However, I think it's really important, to bring in an expert and have that looked at. But ultimately, I think that if you can say with a high level of certainty that
Right.
there's no unauthorized access to your data. That's the real key in my mind.
Which the only reason or the only way you could get to a high level of accuracy is by involving a professional.
That's right.
So the risk would be, I get ransomware. I think that it hasn't gone anywhere. It's just encrypted. I pay the ransom. I get my data back, and I never say anything. But 2 months down the road, I get a call from the Secret Service or the FBI saying that they've traced a credit cards being used in an unauthorized manner. They've traced it back to an incident. In that case, I rolled the dice, right? So I just swept it under the rug, but something got brought up again, and now I didn't follow Ohio's breach notification process because I didn't think anything happened,
right.
But something actually did happen. So there's risk there, right?
There's risk. That's why I think it's really important to do an assessment of what just happened.
Okay.
Because ultimately, if you guess, there's a pretty good probability you could be wrong, and then you find out the hard way, and now you're trying to play catch up. And once it's out there, it's really hard to make the assessment.
Well, we've just had a lot of companies. We get a lot of calls about that. We don't do breach responses for all of them because a lot of companies will say, "Well, I'm just going to pay the ransom. It's cheaper for me to pay the ransom than it is for me to hire a company to come in here and figure it out." So I think they're thinking about it the wrong way. They're thinking, "Well, why would I hire a company to come out here and to just tell me what happened?" Well, because if you're in Ohio, you have a legal responsibility that,
right.
Okay, you have to figure out what happened. Okay, so what are the? We get a lot of companies that approach us and just go out and just in talking with organizations that say, I'm not going to do anything with cybersecurity because I make like flooring tiles and nobody wants anything to do with. Why would anybody want to breach me? I don't have anything. It always starts out with, we only do this, so I don't need to invest in cybersecurity. What are the responses from a legal standpoint? What are the implications of doing nothing?
Yeah, well, ultimately, I have to say that you're not going to, if you do wind up having a data breach, you're not going to be able to invoke the protection of the statute. That's number one. Number two is, who do you do business with? I mean, do they have information? Are you using credit cards in your transaction? Do you have a bank account? I've had, just a bit of a cautionary tale. I had a client that was asked to wire some money, and they thought they were paying a vendor, and it turned out that a hacker intervened in their email communication and sent the wrong kind of wiring instructions. And so the money, which was about $20,000, went to the bad guys, and they got a call from this vendor a day or two later saying,
"Where's my money?
We're still waiting for you to wire this money."
Yeah.
And they said, "What do you mean? We already wired it." These are the kinds of things that are happening all the time now. And by the way, let me just say that a good policy would prohibit your employees from ever sending wire instructions via email. That should only be done verbally, by phone, where you are certain that the person that you're talking to is who you think it is, and vice versa. You have to use, I would say common sense, but it's really you have to have. I think you have to do business with a level of skepticism now to make sure that you're really talking to, or we're really providing data to the person that you think you're providing data to. But to get back to your point, okay, you want to do nothing, you're going to find yourself in those types of situations where you've just, I've got no policy around, wiring instructions. So, good luck when you send $20,000 to the wrong person, or, good luck when somebody steals credit card data from you, or your money gets deposited in the wrong account. I would say, what's the point of doing business if you're just going to open up your doors to the vault and allow people to walk in and take money from you? Because that's ultimately what happens. whether we like it or not, we live in this electronic era where we are highly dependent on passwords and security. And if you're going to just say, not me, I'm not going to do any of that stuff, well, okay, then you've got to live with the consequences of it. But I don't think anybody listening to this podcast wants to live with those consequences.
Yeah, I would hope that no one wants to do that. I think what we've seen over time is things like, especially since we live in Dayton and we're near Wright Pat, right? This is a very heavy aerospace and DoD contractor community, very heavy. And we've seen a lot of very, very small businesses, very small, doing something because, well, they don't want to lose the contract, right? They don't. The DoD is really clamping down. The new CMMC controls have come out, and now if you're a defense company, we'll have a podcast on just nothing but that. But you're going to be required to have an auditor come in and actually certify you before you can even bid. That's big. I mean, that is huge. As of right now, it's just been self-attestation.
Yeah, there's no doubt in my mind. If you're doing business with the government, you're going to have these policies in place. You're going to have to probably have evidence of regular audits. You're going to have insurance. All the things that we've been talking about. You're going to have those things, and then you're just going to have to be develop a culture within your organization so that your employees have this kind of thing on their mind constantly. It's just, there's no doubt.
We one of the things that that we always get is, well, cybersecurity is going to be expensive, but I want to key in on something you just said of developing a culture and educating your employees. Security awareness training, like putting your employees through. I'm not talking about phishing testing, like fish testing, where you send out emails to see if people will click on it, but actual training videos that educate them on what to look for, how to create a strong password, is very economical. I mean, to the tune of probably $30 a year per employee for full training, and still find that a lot of organizations shy away from that. I'm not sure why. I don't know where they're doing the training, but there are a lot of low-hanging fruit. There's a lot of low-hanging fruit in regards to cyber of just, heck, if we just get back to, from the breaches that we've been involved with, and I don't know any of the cases you've been involved with, how many of the cases that you've been involved with involve some super complex, organized crime? Not many, right?
No.
It's been like I didn't patch my system for a year.
Right.
I didn't have antivirus on that machine. I thought I had a firewall and I didn't. We have come into many companies that have firewalls completely misconfigured. Like it might as well just be sitting there doing nothing.
Yeah, in many cases, it's the rogue employee who steals data as they're walking out the door to get to a different job. I can tell you that's probably one of the most common things.
Really?
So just something as simple as an exit interview type process where if somebody's leaving, and managing the hiring and then the termination of the employment process, those are important bookends that can really help secure your data.
Okay.
An employee leaves, are you shutting down their email account? Because what happens is, of course, that email account will get taken and used.
Sure.
These are just some common examples. But in terms of developing a culture, what has to, in my opinion, it has to start at the top of the organization. So if the CEO doesn't think this stuff is important, it's not going to be important in the organization. If it's just the chief information officer who's preaching this stuff, chances are it's probably not going to get done. And you see it at the highest levels in very big corporations all the way down to really small businesses. It has to start at the top. Your leadership has to say, this is important, we're going to do this. And if the lowest level employee is required to, for example, use a complex password, then the CEO can't be using their pet name, pet's name.
Unfortunately, we still see where executives want to be removed from the controls.
Yeah, it just doesn't work. It just doesn't work. And maybe there's a good business reason for them to do that, but ultimately, I think when they're in that work environment, they have to play by the rules, and they've got to say, this is part of our company value system, that we're going to not be sloppy in the way that we handle data and the way that we manage data.
Well, I think the big thing is security is not convenient. So, it's not something that, security doesn't make things easier. It makes things harder. But it's developing that culture, and like you said, and making sure that the employees and the executives understand the reason we're making it harder, the reason we're putting these controls in place is because we're trying to put a reasonable barrier between us and the bad guys.
Right.
And that means that there's certain things that have to happen, whether it's regulatory or it's just best practice, right? It's just good business. All right, so let's kind of just give you the opportunity now to just kind of go through any legal updates or anything interesting relating to cyber.
Yeah, so I spoke about it just a minute ago of the importance of managing those people who are on the inside of your moat. The people who are inside the castle walls, your employees. And you really just have to be aware and assess where your risks are, because that is ultimately where you're most vulnerable. Those are the people who oftentimes have access to the data. And there's so many examples of people who have, from the inside of an organization, committed a breach. They've sent information to the outside. Twitter, Snowden. I mean, there's literally countless examples of that. So having those internal controls is really important. I think that again, managing your hiring, and then at the end of the employment process, how are you managing those situations? And that's a whole other topic, maybe another podcast for another day, of what you should be doing as an employer, just on the data security side. The device, for example, if you own the device and you're giving it to the employee to use, how are you managing the passwords on that device? And are you giving the employee free rein to change those passwords? And what happens if they turn in the device and they don't provide you with the password, which a disgruntled employee may wind up doing? What's your policy say about that? Are you doing audits to make sure that you can access devices, company-issued devices at all times? I mean, these are all things that I see in my cases. I've got a client right now who basically needed information off of a device that a disgruntled employee left, and it's now, password's been changed, the device is encrypted. There's literally no way for us to get that information off, and it's, the employee won't provide it. And that puts us in a difficult scenario.
Well, that's why you have an attorney.
Yeah.
These are all the things, even things that I haven't considered. So maybe we will have a separate podcast to just discuss that.
And let me just say that, again, I'm stressing the importance of managing these things on the front end, because this is in the new era of especially in this work from home era. This whole thing about devices is really critical, because people are taking their devices home. And they're working from home, and they're doing things on them that don't always involve their employment.
Right. Well, the fact that I gave you an open topic and you discussed the inside threat, I think should be an indicator that maybe we should be looking at that. One last question, just because it's been in the back of my mind. I don't want to wait. The employee that resigns and gives 2 weeks notice and is left and is still allowed in the organization, they still have a password, a key code, they have access to data. Is that 2 week period of time, in your opinion, should an employer just if an employee doesn't want to work there any longer, should they just end the employment right there? or is there risk to allowing an employee that's submitted their resignation is going to another company, and we allow them for 2 weeks to have complete access to their job role?
Yeah, I hate to give the lawyer answer, but it will depend. I
Okay.
mean, certainly,
Right.
if the new employer is a competitor and there's a really high risk of losing, trade secrets or important customer information that could be taken over to a competitor, then I think you've really got to assess that situation and act accordingly. On the other hand, if this is somebody who has worked for you for 30 years and they're resigning and you want to give them a clock as they walk out the door or whatever, some kind of retirement gift, then, you don't want to be a jerk about it as the employer. So that's kind of rule number one that I advise my employer clients is don't be a jerk,
right.
But you have the right to protect your stuff, your information, your customers, and you shouldn't take it on the chin either. So it's very highly dependent on the circumstances. And again, this is something that you should be talking to your HR about, and you should be working, if you have an in-house attorney, working with the in-house attorney. If you don't have an in-house attorney, get a relationship with somebody that you can pick up the phone and call and just talk through the legalities of all this stuff.
Right.
'Cause I think that's really important.
Yeah, no, that's great advice. I mean, we've told people many times, even if it's not us, if you have a relationship with another cybersecurity firm or another law firm, just establish that relationship. Have some comfort with a insurance agent that you trust, an attorney that you trust, and a cybersecurity company that can advise you correctly, and I think you'd be covered.
Yeah. I think that having those relationships before the problem is critical.
Great. All right, Andy Vollmar with Bruns, Connell, Vollmar, and Armstrong in Dayton. I really appreciate you coming on the show. We will have you back for another episode. I do want to talk about those devices and access and data privacy. But I appreciate your time today. Thank you for coming on the show. And just really appreciate it.
Yeah, my pleasure. Anytime.
All right. That's it for today. I appreciate you watching this episode number 2. So stay tuned for further episodes, and have a great day. Thanks.